Welcome to the Spirited Agent Podcast. We're pouring wisdom and sipping success one episode at a time. The Spirited Agent was created to empower agents to navigate the ever-evolving world of insurance and grow their business. Grab your glass and let's get inspired to protect your clients from the unknown. Here's your hosts, Millennium Brokerage Group Legacy Planning Executives, Jason Combs and Matt Zelenik.
Hey everyone, and welcome back to the Spirited Agent. Today we've got a special guest with us, Rick Nichols. Rick is an estate tax planning attorney with Bradley. Welcome, Rick. Good to have you.
I'm glad to be here. Thanks for having me,
Thanks
Matt.
for coming.
Appreciate it.
So today, Jason, you want to get into what we're sipping on here?
Yeah, sure. Thanks, Matt. Appreciate it. So we've got a little Elijah Craig today, and this is the Elijah Craig Barrel Proof. And Elijah Craig's actually one of my favorite. And because of it's got a kind of unique story. If you're unfamiliar, Elijah Craig is kind of considered the father of bourbon. It's also many people credit him for kind of inventing bourbon. And it's an interesting story because what happened is he had some barrels that he used to store corn liquor in, and his barn or his shed caught on fire and it burned these barrels. And back in the day, he didn't have a lot of other resources. So he's like, I'm going with what I got. So he put his, clear liquor into the burnt barrels. And at the time, they're shipping them down to New Orleans through the Ohio River down to the Mississippi River. Got down to Mississippi, and by that time, back then, it took a little while to get down there. By the time they got down there, it turned brown, and everybody was sending word back to Kentucky and saying, "Hey, look, this brown liquor is pretty good. Send us some more stuff." And they're a little puzzled, like brown. It went in clear. How did it turn brown? And that's just because, over age, when it goes in and out of the barrel, that gives it a color, gives a lot of the flavor to it. And that's the birth of bourbon whiskey as we know it.
It's a pretty cool story.
Absolutely.
Give a little sip here. It's a pretty classic bourbon profile. A little caramel, a little vanilla. For anybody who cares, this is the A124 batch. So Elijah Craig releases 3 batches of their barrel proof every year, an A, a B, and a C batch. So this was the first batch of last year.
Nice.
Pretty decent. I like the story because I'm more of a clear liquor
Sure.
person. So,
Yeah.
So this resonates with me just a little bit. It started out clear at least.
Yeah. Nice.
So Rick, you're an estate planning attorney and you're an expert on these subject matters. And today we're going to get into, how people can help protect their assets and funds and pass things on to their families. Could you just start off by giving us a base overview of a trust or what type of trusts there are and how they operate?
There really are 2 types of trusts. One is a revocable trust. The other is an irrevocable trust. And as the name suggests, a revocable trust, it's a trust that is for your benefit, for your lifetime. And you can amend it, delete it, move assets in and out of it to the extent that you want. An irrevocable trust is a trust that you create that is for the benefit of your family members, and you can't modify it. It's irrevocable. It is typically used, again, to transfer assets outside of your estate for estate tax purposes. In terms of kind of irrevocable trusts, there are 2 more types. One is the type that's created during lifetime,
Right.
using your lifetime exemption, that example. The other, which is very common, is an irrevocable trust that is created and funded upon your death. So that oftentimes looks like kind of that example of you have children. So in simple terms, wills often look like, if I die, I leave everything to my surviving spouse. And if my spouse has predeceased me, I leave everything in a family trust that the kids cannot terminate, modify, or otherwise have unfettered access to the assets during their lifetime, except for the terms of the trust.
Right.
Revocable, you often hear about as a means by which to avoid having to go through probate. Think of them as maybe a substitute for wills. So again, it is a trust that you would create during your lifetime. You transfer assets into it during your lifetime, or the assets at your death under your will flow into it at your death. But when you die, the terms become irrevocable, and it's usually trust created for the benefit of your family members at that point.
Right. So you had mentioned there, one of the big benefits of a revocable trust is kind of to avoid that probate process. Yeah. So
what does that mean when you hear probate? In Tennessee and every other state, but again, I can speak to Tennessee, the probate process is taking your will. You pass away. Rick Nichols passes away. My spouse takes my will to the local probate court. I live in Davidson County, so the Davidson probate court, and files that with a petition with the court to say, please acknowledge that this is Rick's valid last will and testament, that it's a valid will, and please appoint me as the executor, the person that has the legal authority to administer the estate. And the probate court looks at the will, assuming all is in order, says, yep, this is Rick's last will and testament. It's valid. So it's admitted to probate. And yep, spouse, your name, my wife's name is Amy. Yes, Amy, you are named as executor. You have the legal authority to manage the estate. There is a period, 4 months in Tennessee, where creditors can file claims against the estate if they want to. You deal with any claims that are made against the estate, and then at the end of the day, whatever is left, you distribute those assets according to the terms of the will. When that is done, you file with the probate court another statement basically saying, I've wrapped everything up. Please relieve me of my duty as executor. The court looks and says, yep, looks like everything's done in order. You're finished. A revocable trust is intended to avoid having to go through that probate process. And the way that you do that is you create, again, that trust during your lifetime. I title my assets into the name of that revocable trust. So if I have a brokerage account, a regular bank account, or real estate apart from kind of the house, I title those assets into the name of the revocable trust. I still am dealing with them in the same way that I have been as the owner because I still own them, but now they're in the trust. And when I die, they are not part of my probate estate. So the idea is to have all of your probate assets in the name of that revocable trust, and it serves as a substitute for your will because it will say, upon my death, again, it becomes irrevocable, and here's how all of the assets in my trust will flow to my family members.
So based on everything you've said, it's just a lot simpler to be the person who dies, not the
yeah. and the good news for the males is statistically speaking,
it's us.
Yes,
we take the easy way out, right?
As usual.
Yeah.
Yes.
Right. So back to your thing you just kind of went through, your wife, Amy, will she likely have to hire an attorney to do all that, or?
She probably will need the help of a lawyer at some point. A good example of why you probably would need a lawyer, at least kind of advising you when the first spouse passes away. There's this notion of what's called portability in the estate tax law, and that is basically any of your lifetime or death exemption that you haven't used, it can transfer over to the surviving spouse so that she or he now has your unused exemption, so another 7 tacked on. But to do that, you have to file a return with IRS, typically do within 9 months. There's some exceptions. So that's one example of something that could easily get overlooked.
Oh, yeah. Your average person is going to have
no idea. They'll have no idea. They'll have no idea.
A lot of people throw that out there as a reason why they don't want to do any type of estate planning. Well, I don't want to go through the cost of hiring a lawyer and doing this and get my documents prepared.
Right.
If you don't do it, then you're just putting that off to somebody else to do.
Kicking the can down the road. You're making it much more difficult for a loved one and much more expensive, frankly. And oftentimes, not always, but oftentimes more expensive. So you're deferring work and expense and saying, loved one, you take care of it.
Right.
What I have discovered over practicing for so many years is it's not atypical. And what I mean by that is for adult kids, they usually hold it together when the first parent dies for the benefit of the surviving parent. But when the surviving parent passes away, adult kids oftentimes are at odds with one another.
Right.
And it is obviously, there are varying degrees of that.
Sure.
But it makes it much less likely that there's going to be a significant conflict if you do the planning on the front end versus not doing it and letting the kids sort it out on the back end.
I mean, we've talked about, passing the house and stuff on, but we haven't even touched on if you have a family business or something. I would think that would complicate it.
Yes. Oftentimes there's more than one child. One's oftentimes involved in the business, and maybe the other child or children are not involved. Parents or owner typically wants to treat the children equally in terms of the overall size of their estate, but wants to make sure that the legacy, the business, passes to the child that's actively engaged in the business.
Right.
But at least control and management passes to the child that's actively engaged in the business.
Sure.
And then to equalize the overall estate, you do some things to ensure that kind of the wealth that business is generating passes in some measure to the other children.
If you're a business owner, when it comes to estate planning, what should the business be doing? Maybe buy-sell agreement wise, those type of things.
Looking at your buy-sell agreement with the co-owners and making sure that it's up to date, that it's current, and then looking at your individual estate planning documents to make sure that they align with what the buy-sell provision says. For advisors, it makes sense to talk with their clients, their customers about, one, make sure that there are buy-sell provisions in place to begin with. And if there isn't, then get them in place. And buy-sell provisions typically look like kind of what are the triggering events where the co-owners would say, okay, it makes sense to at least have the option to buy out a co-owner, and whether that's through the company buying them out or individually. And so those triggering events, right, the first one that comes to mind, of course, is death.
Right.
But there are lifetime triggering events too.
Disability.
Exactly. Disability being a big one. Sometimes divorce is taken into account.
The big D's.
Yeah. Heaven forbid insolvency.
Divorce.
Yes, the 3 Ds there. And if there's not proper buy-sell provisions in place, obviously getting them in place and then making sure that your documents, your estate planning documents are in line and that your family member understands kind of how the business will transfer when you die. Oftentimes in those buy-sell provisions, there's an agreed value clause. And a lot of times that says, okay, we will agree to value the company on an annual basis. If we miss 1 year, fine. The last previously agreed value is what we'll use. If we miss 2 years, sometimes it goes out to 3. But if we miss, a couple of years in a row, then we're just going to determine valuation by having the company appraised by outside appraisers.
Right.
And so if your buy-sell provision has an agreed value formula, just make sure you're staying on top of that.
Right.
Yeah. So Rick, in your field there with estate planning and stuff, it's a big topic. Lots of stuff seems like it's going on. But, from your perspective, what's the current landscape like?
Yeah, Jason, thanks for asking. So I think there's a couple of things going on. As both of you probably know, you have an exemption amount, which is the amount that you can leave to your children, your descendants, before any federal estate tax. And you can use that amount during lifetime or at death. And that exemption amount is just shy of $14 million. That's the law that's on the books right now. But as you know, there's a sunset provision in the law. Unless Congress takes some action before Jan 1 of next year, that exemption amount will be cut in half for clients who either are kind of above that 30 million or maybe in that range of 14 to 30 million. And the question is, well, do we make use of our exemption amount, kind of a use it or lose it proposition as to 7 million or so? So do we do something during lifetime, usually by means of irrevocable trust, or do we just kind of take a wait and see approach? It appears, based upon kind of where everything shook out with the election, that exemption amount may get extended for a number of years. Hopefully we'll have a clearer idea within the next few months. So that's kind of the federal estate tax landscape that estate planning lawyers are working with, and kind of take that landscape and see how that applies to our clients and whether it applies at all in terms of their planning. For example, I have a client who is in real estate development, and he's had an incredible run, a net worth of somewhere 40 million upwards, and he anticipates that will just continue to grow. So he looked at the exemption amount and the fact that it's scheduled to go away. It seemed like a no-brainer in the sense of, well, let us use your lifetime exemption now so that if it is repealed, you've made use of that exemption amount during your lifetime. So what does that look like? For him and for many other clients, that means creating an irrevocable trust that is for the benefit of his spouse and family members, and transferring his various real estate interest, usually LLC interest, but transferring those, making a gift of those interests equal to $14 million to that irrevocable trust. So he's removed those assets from his estate when he passes away, plus all the appreciation on those assets that are in the trust.
So I imagine that kind of simplifies the process going forward after you've taken care of that. Now everything extra is now planned for to be taxed, and you're kind of on a singular path. Is that how that? Yeah. So right. So he's used his exemption amount. So what do you do going forward? It does simplify matters, and so a lot of times, kind of next step is to think, well, if I make any transfers, it's taxable because I've used my exemption amount. So what can I do to continue to kind of move assets outside of my estate for estate tax purposes? And oftentimes the answer there is selling those assets to the irrevocable trust that you've already set up. So it's a sale, it's a freezing technique where you take an asset that you expect to continue to appreciate greatly, $1 million asset that you think will be $5 million in a couple of years. You sell that to your irrevocable trust in exchange for $1 million note. So you have basically frozen the appreciation. That's right. And so the appreciation now is growing in the trust, and it's not part of your taxable estate when you pass away.
If it's inside of this trust, how do they manage that moving forward? Is there distributions allowed? All those type of things.
What do clients typically want? They want two things. They want to minimize their tax exposure but they also want to retain control.
Right.
High level, what you end up doing is a bit of a reorganization where you end up with voting units in the LLC and non-voting units. And usually the non-voting units equal roughly 90% of the economic value of that LLC.
Sure.
And those are the assets that you transfer or gift to the trust. So the trust now has the economic benefit of 90% of the LLC, but the founder, the owner, has control by maintaining that voting LLC interest. And then going forward, because he or she does have control, they really control the spigot, so to speak, as to distributions and what are made.
What are some of the things, what maybe another example of somebody that maybe not quite even reaching those exemptions, but just from a planning perspective, they want to kind of get their stuff in order. What are some of the things they ought to be taking a look at?
There are really what I would call or consider kind of core documents, core estate planning documents that every client needs to have in place without regard to the size of their estate. So those core documents generally are, a will or a revocable trust, a healthcare power of attorney, and a durable general power of attorney. Same notion, you become incapacitated, you're naming someone to take care of your personal. Surprisingly enough, documents that several clients just don't have in place. So the starting point is getting those documents in place. And then kind of for the client who is perhaps a younger professional who hasn't had the opportunity to grow their estate yet, you kind of look and say, okay, well, what might make sense if you're kind of on that bubble of maybe you're at 5 million, but you expect to be at 7 to 10 million in 5 years or something like that. So then I think it is get those core documents in place and then think about really easy steps that you can take for estate planning to kind of protect your assets from any estate tax exposure, especially if the exemption is cut in half. And what do I mean by that? Perfect example that, kind of in y'all's world is if they're looking to, if they already have life insurance or they're looking to replace life insurance. So the, $2 million, $5 million, $10 million policy, whatever it is, it usually makes sense just to put that policy into an irrevocable trust, an ILIT, irrevocable life insurance trust for the benefit of your spouse and kids, so that the proceeds are outside of your estate for tax purposes as you move forward.
Pretty simple steps, but talking to somebody like you along the way for somebody in that 5 million or under category can go a long way. Somebody may have a life insurance policy. And you're like, oh, I'm covered, and it's you don't have it in the correct area or such. So one thing Jason and I were talking yesterday, since we got into the estate planning and everything, the show Yellowstone, the whole theme, it boils down to at the very end is they have to get rid of the ranch because they cannot afford the estate tax.
Right.
Is there anything they could have done to actually pass that ranch on?
That liquidity or lack of liquidity is a real issue. I have an estate right now, client owned a number of closely held business interests. It wasn't real estate, but same notion. And we're struggling with coming up with the liquidity to pay the estate tax. And what you don't want is to liquidate those assets in a fire sale and end up selling them for 50% of their worth or even 80% of their true worth. So from a planning perspective, what could they have done better? Life insurance, that really is oftentimes the most common and easiest fix. Even if you don't have life insurance, even if you're struggling with liquidity, IRS will let you defer the estate tax payments, it's not a wonderful result.
Right.
You're paying, the kind of the AFR interest on it, but it is not as though you have to come up with the entire estate tax. The estate tax return and the payment is typically due 9 months after date of death. You can extend that, just like with income taxes, and you can defer payments over a number of years.
And a lot of people don't realize that's really kind of the main benefit of life insurance. It is to provide your family with that instant liquidity. You may have business interests. You may have some investments in the stock market. When that life ends, the state has to be settled. There could be some bills that healthcare type of things. There may be some transfer costs, or you may have to get an attorney that costs money to kind of figure out a lot of this stuff. And I think the life insurance really just allows you to buy that time to make smart decisions about what needs to happen next.
I think a lot of people put, the monetary value on life insurance they're getting back. I'm getting X dollars back, but really you're buying time and flexibility in a time of uncertainty.
That's right.
So it helps with as seamless of a transition as you can have when typically a spouse, when the first spouse, not always, but when the first spouse passes away, and you're dealing with a period of, grief, and you have all of the non-monetary issues that you're going through. Life insurance and the immediate liquidity helps make the financial burden much easier.
Yeah, maybe talk a little bit about, why it is that life insurance is more immediate than other types.
I'll maybe try and answer that question with kind of another real life example that I see on a regular basis.
Sure.
So kind of going back to the client comes in with $5 million, young professionals, minor kids. So they come in and they have a couple $1 million of life insurance or whatever it is. Usually the designated beneficiary is the surviving spouse. Oftentimes the contingent beneficiaries are the kids. So what we'll talk about is, okay, in terms of if you are the first spouse to die, what do you want to happen with your estate? And most clients will say, I just want everything to pass to my spouse outright. Well, what happens if, and the example is, you're taking a vacation, the two of you, and the plane goes down, so you both die simultaneously. What you don't want to happen is for life insurance proceeds, or any assets for that matter, to pass to minor kids, because then you end up with a court-supervised guardianship over those assets. So usually it makes sense to have the contingent beneficiary of those policies changed to where it's a trust that you're creating under your estate, or you can actually just name the estate, and then it flows through your wills into a family trust that you typically set up for the benefit of your minor kids.
Rick, I recently, I think I just read this either yesterday or this morning or something, but I saw a thing that said that 70% of Americans fail to even do any type of estate planning. How are you getting to some of your customers that need this type of planning? And is there more customers that should go through and just a basic estate planning thing and maybe a beneficiary review of the stuff that they do have?
I certainly get a number of referrals from some advisors. Some of them will just say, you need to go see Rick.
Yeah.
And they'll say, just let me know when it's all wrapped up. Others would want to take, very much a hands-on kind of approach. And either is fine with me. I tend to think that it makes sense to have more of a team kind of perspective, because I see things through the prism of an estate planning attorney, and I can have blind spots as to financial advisors and kind of the prism that they're looking at for the benefit of their clients. At the end of the day, it is all intended to benefit and to do good for our
Right.
clients. And that kind of team approach makes sense.
I like how you mentioned the team approach because some people think they can just get like a financial planner and be done, but you can't be an attorney, a financial planner, an insurance expert, all that wrapped up. I mean, okay, if you are, we'd like to find you and hire you. But it's hard to have all that wrapped up in one. There's just a lot to know there.
We're all in the business of helping clients. We're all really good at what we do, and we specialize in various niches. For myself, there's some ego, especially when you start practicing. You tend to want to say, okay, I can take it from here kind of thing.
Right.
But as you mature and you start working with advisors, again, that team approach and listening to different perspectives for the benefit of the client really, to me, is invaluable.
If you've got a home, primary residence, and here in Nashville, we've seen those values skyrocket. Right? Or even retirement accounts. So their home may be their biggest asset, and their retirement account could quite possibly be their second biggest asset. And so, at least when it comes to their home, most people are kind of interested to say, all right, how do I get that to the next generation, in an efficient way?
Oftentimes, this conversation comes up in kind of a broader context, for me, at least in my practice, in terms of asset protection. Not necessarily a tax-driven discussion, but is there anything that we should be doing with our house to protect against, heaven forbid, a judgment against us? Client is in a car accident.
Sure.
They're deemed to be at fault. There's a judgment for $1 million in excess of their life insurance policy, something like that. What do we do with our house, if anything, to protect against that judgment creditor being able to come and take our house? It makes the most sense to leave your house titled as it is, and that's usually titled jointly with your spouse. And here's why there is the exclusion from capital gains on the sale of a primary residence up to $500,000. If you transfer your house to an LLC for asset protection purposes, for example, that you're not inadvertently blowing that capital gains exclusion because it's now owned by an entity versus two individuals. There is a fair amount of asset protection baked into the way your assets are titled, at least in Tennessee, in most other states, but certainly Tennessee. That's what I can speak to. And what I mean by that is if you have your house and any other asset titled jointly with your spouse, it's really tenants by the entireties is kind of the technical designation.
I'm going to start calling my wife my tenant.
Yeah.
See how that goes for me.
By the entirety now. But,
next time you
in
see
the
me, I'll
entirety.
still be sleeping right here.
But the idea there is, if back to that example of the car accident, if it's one spouse who is in the car accident, who has the judgment against them, and that creditor tries to execute on that judgment, the other spouse can step in and say, no, because I own this to the same extent that my spouse does. So as long as I'm alive, you can't do that. And creditors are staying at bay because of that.
And what considerations should people be thinking about as far as the retirement accounts are concerned?
Yeah, with retirement accounts, qualified plans, it's more important, critical to have the designated beneficiary correct. Usually, again, you'll want to leave the spouse as the primary beneficiary so that the spouse can inherit those retirement accounts, roll them over into their own, and continue to defer having to take minimum distributions.
Right.
But with children, whether minors or adults, the conversation really and what to do with retirement accounts is driven oftentimes by kind of the larger question of how do you want your assets, your estate to pass to your kids? So that oftentimes is changing the contingent beneficiary to a trust that you're creating under your will, typically for the benefit of your kids.
All right. So we talked a little bit about real estate earlier. So what are some of the considerations clients should think about if they have income producing real estate, and if they're looking at maybe putting those into a trust or not putting them into a trust?
The consideration there is more asset protection planning versus minimizing your taxes for estate tax. And what I mean by that is it is fairly common for clients to come to me and say, hey, I've got this rental property that's income producing. We've got tenants there, and I own that individually. Is there anything I should do with that? And I'll say, yes, absolutely. There is something that you should do with that. And the primary reason is because of the exposure that you have currently. Your entire net worth is at risk if there's a lawsuit in connection with the building. You look at moving that either in an irrevocable trust, so it's outside of your ownership. Now the trust owns it, and the trust's only asset is that commercial
property,
real estate. Right. So you've kind of siloed that risk. And you do that in a way for income tax purposes to where it's basically neutral. And what I mean by that is the type of trust would be what's called a grantor trust for income tax purposes. So for tax purposes, you're still treated as owning that real estate, and the dividends, the interest, the rental payments that's flowing off of it, you're still picking up on your 1040. So no adverse tax consequences to doing that, but you've moved it to now a vehicle where it is judgment proof in terms of your other assets.
Sure. In the examples you've used so far, you're individually owning this property. What if you're in it with a group of people and you own a fractional share of that property? Are there some things that you need to consider in that scenario?
I had a Zoom call a week ago on this very issue. They're investing in a real estate venture, and the question is, how should they own their interest? Oftentimes it is own it in a limited liability company and know that you're going to pay the F&E tax, but think of it as just an added insurance cost, and that's where they landed. Or the alternative is to create what's called a Tennessee Investment Services Trust, which is an asset protection trust that you create, and you transfer your membership interest in that real estate venture to that asset protection trust.
Sure.
So you've siloed kind of that risk through that asset protection trust, and because it's in a trust, you're not subject to the F&E tax at that level.
Rick, thank you for being with us. But there's a lot of value in creating some partnerships in the marketplace with a planning attorney that focuses in on estates. I mean, our goal here is to help customers. If you're trying to sell some life insurance, there could be a real need for it inside of a trust or a buy-sell agreement. So I think it's paramount to have a relationship with somebody like yourself in the marketplace. And if you're an agent out there and you don't have a partnership now, I mean, we can help you kind of create some of those partnerships in the marketplace. And it's a good way to do some events like this and educate more customers. I mean, I think that's one thing that we talk a lot about in our business, is just educating customers on the need for this type of planning and other types of planning. But that's a great way to do it, is to create the partnerships with guys like yourself to help educate customers and get things kind of implemented.
Well, thank you for having me.
Thanks for being here.
Thoroughly.